Okay, welcome to this presentation, FTC Crackdown of 2025, Essential Compliance Strategies and Earnings Claims, Testimonials, and Subscriptions. This is the stuff you really need to know about. We had actually had a coaching call last night, and we covered some of this stuff. So I want to welcome some of you here. There's Ethan Miller, Austin, Texas, great, right down the road from me. Sophia, Miami, Emma, Los Angeles. Yep. See you saying hello. Everybody saying hello. Henry Baker, Alexandra, Harper. Where are you from, Harper? Oh, you're San Diego. Okay. Michael Rivera, Houston. Again, that's not far from me. Here's somebody from Philadelphia. Can't pronounce your name. The last name is Allen. William Campbell, Chloe, Ella from Charlotte. Who else we have in here? Go ahead and post your name in here if you got in there, Zoe. There we go. Hello, Brent. Chandler, Arizona. Penelope Brooks from Burlington, Vermont. Isabella Lewis, Phoenix. All right, sounds good. Okay, guys, it looks like we're getting a recording. We've got a lot of feedback here in the question box. So what I'm going to do, and I apologize if you see me look in this direction. It's because that's where my screen is. Got a couple of screens, and I'm looking at the question box and everything over on this side. So what I'm going to do is I'm going to turn this over to Chip, my partner here in FTC Guardian, the attorney, FTC compliance attorney. So he's going to be the presenter and go over everything. And I'm going to mute my mic and turn off my camera. And I will be back towards the end when we start taking questions and all that kind of stuff. And we'll get all your questions answered as well. So Chip, are you ready?
I'm ready. Let's go.
All right, go after it. I'm going to turn my screen off.
Okay, so you see the title screen there, and you see that we're going to be talking about three areas where there is a lot of new material that's going to be very much what you're involved in if you're fairly typical in an online marketing situation in 2025. So let's get down to it. Obviously, you see those three areas: earnings claims, testimonials, and subscriptions. And a quick introduction here for the purpose of sort of making a case that I'm qualified to bring this presentation to you. I'm a graduate of Wake Forest School of Law, and I've also served as professor there, adjunct professor, for over 20 years. A few years ago, I attended the University of Georgia Graduate School of Business. I'm very proud of this award. It's a preeminent AV award by Martindale-Hubbell, and it's all based on secret ballot by other attorneys. So it's not something that you sort of pay for. You've really got to earn it. I've been interviewed on television a few times. I've authored a couple of books in the area of FTC compliance for small to middle-sized businesses, and I am of counsel to the Atlanta firm of Jones and Haley. That's a picture of the Atlanta skyline, and here is my separate website, ecommerceattorney.io. There's a clip there of part of the home page, and we've got a housekeeping announcement. This presentation is for informational purposes only. It is not legal advice. We're not affiliated with the FTC, and we're not going to cover every single requirement, only the main points. So that's the intro. And of course, you saw at the very beginning, we're going to be covering these three areas. So let's jump into earnings claims. And of course, the headline there is why you need to say goodbye to your earnings claims disclaimer habit. Two big takeaways here. The first one is earnings claim disclaimers are no longer effective for earnings claim compliance. And this has been a strategy for a long time, to have an over-the-top earnings claim, make $10,000 in your first month or whatever, or a testimonial that's saying essentially the same thing, and then use a disclaimer to say results not typical, and a few other things that we'll see in just a minute. So one of the big cases in 2023 that is very, very much involved in the development of what I call the new FTC framework for earnings claims This is an example of learned back in 2023 of a disclaimer. Many of our products and promotions provide information about potential income. Well, they certainly did in a big way that you may earn. These representations are not intended to describe a certain outcome or even a typical outcome. In other words, a disclaimer that whatever you see claimed here is not typical. And you see below the horizontal line, the problem with that the FTC had is that the disclaimer contradicted the net impression of their ad claims or earnings claims, which were essentially you'll earn a lot of money, basically. And so now they're undercutting and contradicting that with this disclaimer. Very, very typical. Here's another one. We do not actively conduct research as to what the typical outcome is for individual offerings. So we're not saying that anything is typical in the first one, and now we relate to it in number two. We don't do any research, so we don't know what is typical. And of course, the FTC wants consumers who are viewing these earnings claims to understand what is typical, right? So the allegations were, you see here by the FTC, defendants' disclaimers directly contradict the message that was conveyed in their earnings claims. Essentially, that consumers are likely to earn a substantial income. And then second, they had no basis to substantiate or support their earnings claims. Those are the two big allegations by the FTC. And here is takeaway number two. Number one, you recall, is don't rely on a strategy-based program or approach to compliance for earnings claims anymore. The maximum or max strategy approach, I call it, doesn't work. In fact, the FTC views the continuation of a max strategy approach almost as a deceptive marketing practice in and of itself. Now we get to the framework. And if you look at this, there is essentially part one and then parts 2 and 3 in orange at the bottom. Part 1 with subparts 1.1 and 1.2 have been around since 2009, but the FTC sort of allowed this disclaimer strategy to neutralize it for a very substantial period of time up until about 2021, 2022. So this is the framework. It's extremely important. And here it is. Number one, earnings claims are typicality claims. That's the net impression, meaning that a consumer acting reasonably is going to infer that the claim that you'll make a lot of money or maybe specific amounts is typical. That's the claimed result in the earnings claim. A lot of money, generally speaking, or a specific amount. They're likely to infer that it is typical and therefore conclude that if that's the claimed result and it's typical, then I should be able to achieve pretty close to the same result, right? And so the earnings claims are typicality claims, and you need to substantiate that most participants can achieve the same result that is claimed, right? That's the essence of number one. Or in the alternative, there's an either or here, you need to either demonstrate or disclose what is typical. So you need to substantiate what is typical, or if the claims substantiate that the claims made are typical, or if they're not, then disclose what is typical in the form of a generally expected results disclosure. And we get into the more recent additions, beginning 21, 22, 23, you need to also track participant results without disclaimers that contradict net impression, duty to track, and the generally expected results. So now it all comes together, and this framework does not permit a marketer to avoid typicality. And that's really a big problem for marketers who are continuing with the maximum disclaimer strategy. So you probably know that FTC Guardian is the leader in terms of online coaching for online marketers for compliance, primarily with FTC guidelines and rules, but there's also more to it. We've been very much involved in what is going on with particularly the FTC involving AI. And also we branch off into other areas that are very much applicable to what the typical earnings, not just earnings claim, but the typical marketer is involved in. And one of those is copyright. There's a connection with copyright into AI, very important issues there. There's also copyright, for example, involved in what people are doing with blog posts, that sort of thing, or whatever content they're creating. But our centralized focus is FTC framework. So when you sign up, and Alan is going to explain a little bit about what we have to offer and why we think it's important at the end of the presentation. But I'm here to tell you that when you do sign up, there's some things that you're going to get as a member, a member of FTC Guardian, a pro-level member. One would be a coaching session replay video back in August where we covered this topic in much more detail. There was a lot of Q&A. You get the advantage of all of that, but you have the download of the infographic itself, the earnings claims framework. So that's involved when you sign up as a member a little bit later on. So let's move on to the presentation and get into testimonials, really important. And you look at the last two issues we're going to be talking about, testimonials and subscriptions. Some of you might be involved in earnings claims. You might not be. But if you're a typical online marketer, you're probably already involved in reviews and testimonials and perhaps subscriptions, $30 a month until you cancel. That's what we're talking about. Or if you're not involved now, you're very likely to maybe become involved in 2025. And there are a lot of very new developments here. So let's jump into testimonials, and you'll see that there is a new FTC rule that was effective back in just October of this year, October 21st to be exact. And let's get into it and see what we're talking about. So here it is, the new FTC rule effective already in October regarding consumer reviews and testimonials. And it's really important to understand what the rule is all about, right? So we have the difference between guidelines and rules, right? So we have the 2023 revised FTC guidelines regarding reviews and testimonials. And the takeaway here is that a guideline is sort of like the FTC is suggesting principles that you need to follow for certain things, right? And I'll use an example that has nothing to do with testimonials, but I think it's so easy to understand if we're going to later be talking about subscriptions. So a guideline would be, for example, you need to make it relatively easy for a consumer to opt out of a subscription, which automatically renews until the member opts out. So within a guideline, there may be 4 or 5 ways that you can go about making it easy in a way that qualifies for being easy enough, right? But if you are talking about a final rule by the FTC, not just a guideline, then things are quite different, because the rule would not give you the latitude or the wiggle room to figure out a way to solve the issue without, you can use your own judgment within certain parameters. But with a rule, there's only one way to go about satisfying it. And the classic example for a subscription would be you've got to have a one click to cancel, period. And if you don't, you're in default. The rules have the force of law. The violation is a per se deceptive practice. There are fines, and you see at the bottom there, over almost $52,000 per violation, and the per violation is counted in different ways. It can be the number of days that you've been in violation. almost $52,000 a day, or it can be counted in terms of the number of consumers that were essentially deceived, right? So we're talking about here a final rule where there's no wiggle room and there are very significant fines for violation, right? So let's get a quick understanding of the difference between a consumer review on the one hand and a testimonial on the other. And you see there, it's an evaluation of a product, et cetera. But the key is the fourth bullet there. It is published on a website or platform that's dedicated to receive evaluations, right? Now, that may be something like Amazon, for example, where they have dedicated forms to, provide an evaluation, or it can be your website, or it can be an intermediary that specializes in capturing reviews for marketers, right? So it's based on a platform that is dedicated to receive these reviews, right? And they also, in many cases, involve star reviews, 5 stars or 2 stars or 3 or whatever. That's a consumer review. Now, a testimonial is somewhat similar, except that it's not registered to a platform. It's just an advertising promotional message that indicates that the person giving the testimonial has certain opinions, beliefs, and experiences about a product or service that they've either bought or used or somehow had experience with. And one example would be they've tested it. They haven't bought it or used it, but they've tested it. So that's the difference between a review and a customer testimonial. So I'm going to run through fairly quickly what these new rules are. Very, very important to be strictly compliant with these new rules going forward into 2025. And at the very top with that little arrow, that's what we're going to be focusing on, and then as a bullet point. And then below that, there's some actual bullet points that sort of illustrate and give information. So basically, the number one, a fake or false review, is a review that misrepresents something, either the identity or the reviewer's identity, or including you doing it by AI, or there's a false claim of experiences, and it applies to insiders and other parties. And a violation is in creating, purchasing, selling, or disseminating this fake or false review. Now, an incentivized review is banned. You see at the very top, that's the essence of it. If there is compensation or other incentives for expressing a particular sentiment, and usually this sentiment is a very positive review, positive things being said or written. Oh, and also applies to conditioning incentives on a specific review, whether positive or negative. So that's what an incentivized review is, and it's obviously banned by the new rule. Also, insider reviews and testimonials focuses on material connections between the person reviewing and the business that is selling a product. And it involves insiders such as officers, managers, employees, or relatives of the business that is selling. And there needs to be a message, a disclosure of this material connection. You don't want officers of a company selling a product masquerading as an independent testimonialist. And the FTC says there needs to be a clear and conspicuous disclosure that this person is an officer or manager of the company. And it also creates an obligation within the company that's doing the advertising to instruct employees about their responsibilities to provide these types of disclosures. Another issue that is also covered by the rule is company controlled websites. And the idea here is if you're a marketer and you want to give the appearance of independent reviews or testimonials for your product, what you might do, and a number of companies have done it, and that's why it's now outlawed or banned in the new rule, they'll set up a separate website that appears to be completely independent of the marketer's website, and then they will invite influencers, let's say, to give all sorts of what appear to be completely independent reviews that are very positive about this particular product. There's been a number of cases involving that. And so the advertiser, you see the bullet points there, this is the collection of elements that are going to be involved in a violation. There's a misrepresentation of a review site that the advertiser actually controls as independent if the site is owned or controlled by the advertiser and features products or services. So you cannot have what is appearing to be, but not actually independent, and then other people giving reviews to the so-called independent website. And then fake social media indicators. And of course, you see the focus is on the banned fake social media indicators. It can be likes, it can be all sorts of indications of following on social media. And the key is they're typically generated by bots. They're not associated with a real person at all. AI is typically involved now. And they evolve, in many cases, involve accounts created with a real person's personal information without their consent. So you sort of hijack a person's identity and then use that person that's a real person, but not actually making the review or testimonial, basically a hijacked account. So that is now banned. Fake social media indicators. And this involves the creation of those things, and then the other aspect of the same fake social media indicators is distributing those. So if you make them, create them, on the one hand, that's a big problem. Or if you're a middleman and you're distributing them, it's also another big problem. There's an exclusion for somebody who just had no idea that they were in the process of distributing a fake. So there's some savings clauses there, but really they're coming down pretty hard on fake social media indicators. And then finally, review suppression. And what has happened here with a number of cases is if you're a marketer, you hire a third party, a completely independent company that will create reviews for you. And then, they're legitimate reviews, and then they send them to you. So you're receiving these reviews that are collected for you by an agent of yours, let's say. But what is happening here is, it's basically the 5-star review system, and you're getting the whole gamut. You're getting 5 stars, 4, 3, 2, 1, and you're deciding, well, let's throw out all the 1s and 2s, right? We throw those out. They've been collected. All of these have been collected and sent to you by the collection agent. So you're saying, well, let's throw out the 1s and 2s, and let's put in maybe a half of the 3s and do a lot of the 4s and every one of the 5s. So you're basically suppressing the less favorable reviews, right? And that's now a big problem and a violation of the new rule. Now, there are some similar types of suppression that are allowed, right? And so basically, let's say that you're getting all these reviews in, and you've decided that reviews that are dated prior to 2 years ago, 3 years and older, are just not fresh enough to be representative of what you're doing now. So you're actually suppressing real reviews for 3 years and older, and that's fine, right? As long as it's done uniformly, right? And if you're throwing out reviews that are clearly false, that's okay. And any review, regardless of whether it's favorable or not, that has all sorts of harassing language, abusive, obscene, vulgar, sexually explicit content, anything that would be objectionable, it's okay to exclude those as well. But generally speaking, review suppression, picking and choosing, is really a big problem these days. So big takeaways here regarding reviews and testimonials. There are 6 categories. We've been through them very quickly of deceptive conduct. There are significant risks with compliance. AI figures into a lot of this, as you probably figured out during our quick run through this. And strict compliance, as I mentioned earlier, is absolutely required. These are not guidelines or guides, as the FTC says. These are statutory requirements. Strict compliance is required, and the violation per day or per consumer, however they figure that out, is almost $52,000 per violation. So what's in it for you if you sign up, when Alan explains what it's like and what the benefits are of becoming a member, a pro-level member on FTC Guardian? Back in September, specifically September the 10th, we had a long coaching session on this new rule that was about to become in effect. And we have a coaching video with a lot of Q&A. We have PDF downloads with an infographic, all of the bullet points, and we have as a handout, which we typically have for our topic presentations that are part of our coaching program, we have additional documents that I have come up with. Some of them are from law firms who have written articles about the specific topic that we're talking about that are really good as takeaway material. And in this particular presentation on fake reviews, I had 3 of those converted to PDF, downloadable, to supplement the takeaway from the coaching session, the infographic, and the video replay. So you take advantage of all of that when you sign up. Will really give you what you really need to do moving into 2025 to make sure you're on the right side of the FTC with respect to reviews and testimonials. Then we get to the final of the 3, subscriptions. And now there is it is probably there's probably more ways that you can trip up with subscriptions than either of the earnings claims and testimonials. And we're talking about here a new FTC rule and also a California statute, generally known as the California Auto Renew Law, that's been in effect for several years, but now there are very substantial amendments. And they're talking about a lot of the same things. We'll jump into that and give you some idea. So basically, what are we talking about with respect to when these new requirements come into effect? Well, you see at the very top of the slide, the negative option rule becomes effective and enforceable in May of 2025, specifically May 14. So you've got a period of time to get your ducks in a row to avoid some serious trouble. And then, of course, the California Auto Renew Law, which I use the acronym CARL or CARL, you've got another couple of 3 months to July 1. So once you get past May, you're going to be in a situation where you need to be in strict compliance. And so you've got plenty of time, and we've got the material to help you be in compliance. So what are we really talking about here with both the FTC negative option rule and the California CARL Auto Renew Statute amendment? What are we talking about? This is it at the bottom. This is what is covered. The offer of a service or subscription that will continue, and this is the key, it will continue to renew automatically. That's where we get the California Auto Renew Law name. The service or subscription will continue until the purchaser exercises affirmatively by taking an affirmative step to cancel the subscription, right? So anything that renews automatically, service or subscription, and continues to do so until the participant takes an affirmative step to stop it. So basically, if you're selling something and you say you can use this for 3 years, and then at the end of 3 years you need to take you've got a license to use this product or service for 3 years. At the end of 3 years, it terminates, and you have to take an affirmative step to re-up. That is not a subscription. The key to it is, in a subscription, it automatically renews theoretically forever until the participant takes an affirmative step to cancel. And you're probably familiar with forgetting perhaps that you're subscribing to something and you miss a termination or cancellation date. So it's another annual renewal, that sort of thing. Or you may have experience where you have tried, you know that the renewal is coming up, and you've tried to cancel to avoid, and say, for example, an annual renewal, but you can't figure out how to do it because the marketer has made it difficult for you, right? That's a serious problem. But we're now focusing not on those problems for consumers. We're talking about the problems for marketers in setting up a subscription legally and not be dinged either by the FTC or the state of California. Now, there are about, I'm thinking, 34 or 35 other states that have auto renew laws, but California is probably the leader in terms of how strict they are. So if you are generally speaking in compliance with the FTC rule in California, you're probably going to be in good shape. All right, we're not going to run through all of the requirements of both the FTC rule and Carl. We're going to hit the high spots and then provide some information about how you can get a downloadable checklist of all of these requirements. All right, so one of the key concepts of these new requirements is there needs to be a separate consent. So you see in the third bullet there, what has happened in a lot of cases is there are terms and conditions for the subscription. And typically you'll see a button there or maybe an unchecked box. And then beside it, it'll say your acceptance indicates not only that you agree to the terms and conditions, the legal terms and conditions, but that you also agree to the amount you're going to be charged. Your credit card's going to be charged, right? So one little click or check mark indicates acceptance to everything. The subscription terms, that, you know, whatever it is and how they renew and all of that, and the legal terms, one little click or check marks. That won't work anymore. There needs to be a separate acceptance of the subscription terms and then a separate acceptance of the terms and conditions, right? And there needs to be record keeping of the consent given for the subscription 3 years or 1 year after cancellation, whichever is longer. So now you need to not only get a separate acceptance to the subscription terms, but you need to provide a record, essentially a dated record of that consent for that specific participant for 3 years, basically, right? So one other little aside is if you've got a contract, if it's all set up properly and you've got the offer acceptance and you know the acceptance by the click or the checkbox. So let's say, separate from what we're talking about here, you need to actually enforce this contract against someone who's breached it, right? Well, you're going to need the same record keeping in order to go into a court of law and make a claim. So if you're at the old-fashioned paper version signed by pen and ink, that's what you've got to do if you're going to enforce a contract. You've got to submit it into evidence and prove that there was a binding agreement there in the form of a contract. Now, we're not talking about the binding agreement. We're just talking about what you need to do to be in compliant with these new rules. There is a record-keeping requirement. And now you probably read something about this major new requirement that's typically referred to as one click to cancel. And basically the idea is that if the consumer accepts by clicking or checking a box, then cancellation has to be by the same method. And generally speaking, most of the acceptance is online by clicking or checking, right? Which means now you've got to have that one click or one check to cancel. Very similar in concept. And then at the very bottom, you see that it's got to be easy to cancel. It's got to be the same way to cancel that you use for acceptance. And at the very bottom, when you say click to cancel, it's got to result in an immediate prompt cancellation. It can't be, oh, well, it's going to take a while. It's got to be immediate to cancel this subscription. And there also is some new requirements regarding save attempts. So a save attempt is a marketer's attempt to intervene, let's say, when a participant is attempting to cancel, right? And in some cases, the requirement was to call a certain number by telephone. And then there are other ways to go about doing it. And you see, and you can still do this online. I remember not long ago, I was canceling a subscription, and as I click the button to cancel, I get this notice. Well, what about if you continue and we give you a discount, right? Or, and you try to cancel again. Well, what about if we not only give you a discount, but we'll give you a related service that's somewhat similar if you just continue? So that's called a save, where you're trying to save that customer who's trying to cancel, right? And so the negative option rule, the federal rule, is actually silent on saves, right? It just doesn't say that it's permitted or not. But the California statute allows a save if it's by telephone. There has to be a notice that the consumer may cancel at any time. And if there's a save offer, there needs to be a click to cancel button. So you can still have saves under the California rules, but there's some conditions attached. Now, you probably have heard of dark patterns. Essentially, a dark pattern, usually at the very beginning of this concept of dark patterns a few years ago, was related to screens, user interfaces that are designed to guide and in some cases to trick a consumer into an action that the consumer probably didn't intend to take. So the FTC rule prohibits anything that interferes with, detracts from, contradicts, or otherwise undermines consent, right? And the California statute basically, in so many words, is the same thing: prohibits steps that delay a buyer's ability to immediately cancel. So the term, in quotes, dark patterns, is not used in both the federal rule and the California statute. But the text describes conduct that generally falls into the category of traditionally dark patterns. Now, you may not be aware that the FTC has been litigating for a little over a year a claim against Amazon Prime, alleging that Amazon Prime essentially used dark patterns to trick someone into signing up for Prime, and dark patterns to make it difficult to cancel out. And so that is an interesting case, and a lot of attorneys who work in the area of subscription compliance are scratching their heads a little bit about, they understand what the actual situation is with Amazon Prime, and they're thinking, if Amazon Prime, I've read several articles by attorneys who say, if Amazon Prime is really liable for a deceptive marketing practice in violation of the federal rule, then they're probably half of the other marketers in the U.S. are also liable or potentially liable as well. So that's a case that we're all going to be watching. Now, here is a new requirement that is quite unusual, and I think has surprised a lot of people. because the new requirements, again, effective, the latter one, July 1, and the May one a little earlier, most of the conversation and articles and blog posts that you might read are talking about, one click to cancel and that sort of thing. However, there's not been a lot of discussion about this, but when you hear what I'm about to tell you, it's really amazing what I think amounts to overreach by the FTC. So here's what we're talking about. Let's say that you're a marketer and you're marketing money-making opportunities with earnings claims, right? So there's a whole set of rules or regulations and past history of other enforcement actions that indicate what the guidelines are for earnings claims. And so you're basically in compliance with that, or think you are. And then on the other hand, the money-making opportunity, say a coaching program that you're selling, is also being paid for through a subscription program instead of just a single lump sum payment. So you've got a subscription, and then what you're selling with the subscription, let's say, is earnings claims. So let's say, for example, that you are in compliance with both the new federal rule and the updated amendments to the California rule that we've just seen some of the main points for. You really have done your homework, and you've got the one click to cancel and all this other stuff under control. You're in compliance in terms of subscriptions, but then you're selling into that subscription with an earnings claim. And let's say you are a little bit deceptive or you misrepresent something about the earnings claim. And that misrepresentation has nothing to do about how the subscription is working and whether it's in compliance. So even if you're in compliance with the subscription requirements, if you make a misrepresentation related to it in the example of the earnings claim, then you're automatically liable for the rules and the incredible results in terms of fines regarding the subscription rules. So that's where the material misrepresentations comes in. It's very, very new. And you see at the bottom, almost $52,000 per violation for the FTC rule. And Carl is $2,500 plus full refunds and a private right of action, meaning that, you see on TV these attorneys, plaintiffs' attorneys who are basically personal injury attorneys, they're now able to actually initiate lawsuits for individual clients in this area. A brand new concept carries with it a lot of potential liability. So when you sign up, and Alan's going to explain how to go about doing it and why you probably should, there's a little bit more for me coming up. I think in terms of what you get specifically, other than generally speaking, a membership to the coaching and a few other things as well in FTC Guardian, the single biggest takeaway that has the greatest value is in pink at the bottom of this slide. You also, well, first of all, you get a coaching session, a replay video back in December, just a month ago, December 10th, on both of these two new sets of requirements. But at that time, we provided an infographic, but the big deal is a comprehensive subscription checklist for compliance with both FTC and California. And it's very detailed. It's not just a fairly rudimentary little checklist. It goes into great detail on what you need to do for compliance with both the new federal rule, final rule, and the California CRL amendments and updates. So that, to me, would be the single biggest takeaway in terms of what you might get after you sign up. So let's quickly look at how the FTC might target you if you're not in compliance with earnings claims, testimonials and reviews, and certainly under these massive new requirements for subscriptions. And the old school approach is, they basically can look at your website and see, that you're selling through subscriptions. They can check it all out. They can see the earnings claims. They can see whether you've, got disclaimers or not, which are not they don't work anymore. All these things are available 24/7 just by viewing your website. Very easy. Also, the FTC has a complaint form, and the FTC really, really looks for complaints. They look for complaints the way you as a marketer looks for leads to sell things, right? And there's a video on the FTC website that explains how to fill out a very comprehensive complaint form, and this is a clip of that. Also, the FTC uses the same type of technology that you might use in a marketing funnel, but they use it to funnel complaints, and they get a lot of complaints from the Better Business Bureau. A lot of them come there. There's also a division of the Better Business Bureau known as the National Advertising Division, which does reviews, independent reviews of websites and marketing advertising claims. And they also do reviews when one advertiser is claiming false advertising by a competitor. They do a lot of that. And if for example, the NAD, which is the acronym, if they make a recommendation in a case they're reviewing and the affected company does not follow the recommendation, then NAD typically refers that to the FTC. And there are consumer-friendly websites like truthandadvertising.org. They send complaints to the FTC, and then there are a lot of complaints that come from competitors. They all funnel in, and they use this funnel the way you use leads in a marketing funnel, right? So basically, what does all of this stuff actually mean for you? So we've covered a lot of stuff. You may have questions. Basically, I think the big takeaway is if you're not up to speed with all of the new requirements, if you're using the same old marketing compliance, for example, if you follow the same thing that's been working for earnings claims, you're in serious trouble, right? If you follow the same thing that for a lot of the practices with reviews and testimonials, you're in trouble. If you do the same sort of thing, particularly with subscriptions, and if you're not upgrading your compliance in these three areas, you're in serious trouble. Outdated marketing compliance is just not going to work. So there's risk associated with, not keeping up, right? So how do you evaluate the risk? Well, there are really only two ways if you think about it. One is if something goes wrong, how big a loss is it? What is the impact of a loss on your failure to keep up with compliance, say in the three areas we've talked about? Well, it's pretty big. You've seen the dollar amounts, and they can be extremely high because the fines are by day or by affected consumer. You could talk millions of dollars. So the impact, particularly of fines, can be massive, right? So then the other factor to sort of weigh is, all right, the impact is really bad, you can't live with it, but how likely is it to happen? And I think the likelihood is increasing because, as you see, or we'll see in just a minute, the FTC is using AI to, find out who's in compliance and who's not. So bottom line, if you decide that the impact is particularly high in terms of fines and that the likelihood is getting, more likely, and both of those are relatively high in probability, then it probably makes sense to take some kind of action to mitigate the situation. So here is my case for how the FTC is using AI to surveil what you're doing in the marketplace online. So this is taken, I believe, a year and a half ago from the FTC, maybe 2 years ago, from the FTC website, where they are looking to hire people who are really experienced in AI, right? And so you see here, candidates, high quality experience AI, what you'll do, and the one line description about what they want these people who become employees to do is to participate in law enforcement investigations. So this backs up what I said just a minute ago, that they're using AI to figure out, who is in compliance and who isn't. But if you're not sure, I'm going to just bandy around some of the yellow text. Support law enforcement investigations and actions, support investigations into business practices, developing appropriate investigative techniques, creation of effective remedies, support litigation teams. So all of that taken together should let you know that it's not the old tried and true anymore, that they're using AI technology to decide who to go after, because they can pretty quickly determine who's in compliance and who isn't. And prior to that, back in 2018, they were also involved in big data analysis, because they were really trying to look at what was going on generally in the marketplace and how evolving technology could result in computer injury. So way back in 2018, they started hiring technology experts, in this case in big data, but much more recently in AI. So they've been doing this for a long time. Bottom line, this is really, Big Brother is watching you. That's a cliche, but it's true, right? And you cannot fly under the radar. A few years ago, you could argue that, okay, the violation is pretty serious and has very serious consequences, but the likelihood of being caught in an enforcement action is relatively low, because you're a smaller, middle-sized company and you're sort of flying under the radar. But they're using AI now, so that flying under the radar doesn't quite work anymore. So faced with all of this, what about you? Do you have really a reliable source of information to help you navigate these new requirements? And does the new source provide live presentations with coaching and unlimited Q&A? That's clearly, you figured out what FTC Guardian offers. However, you might think, well, of course, we can get that same information from an attorney. And yes, you can. The problem is it's relatively expensive. It's what I do, right? It's relatively expensive. And generally speaking, lawyers are not involved in coaching. They do some. They give very specific advice regarding specific issues and fact patterns, but they don't provide overall training or coaching. If they did, it'd be pretty darn expensive. However, FTC Guardian is not a substitute for a licensed attorney. We're not a law firm. We're not practicing law. Now, I've practiced law separate from FTC Guardian through the Jones and Haley law firm in Atlanta. But I work with as a founder and an officer in FTC Guardian, Inc., to provide coaching services, not legal services in the form of legal attorney-client relations, that sort of thing. So attorneys provide a very valuable service. Generally speaking, they don't do what we do at FTC Guardian. So the next biggest option you have, the next best one, other than an attorney, is, we believe, FTC Guardian, because we provide sort of an educational and coaching service to help you stay, come up with exactly what's happened and then how to navigate them. And there's our logo there, the FTC Guardian verified member. So way back in 2014, at the beginning of this presentation, Alan mentioned that's when we formed FTC Guardian, which of course is true. But prior to deciding to go forward with a new venture, FTC Guardian, Alan and I sat down a couple of three times and tried to map out what it is we were going to really do and what it is that we felt like we had to do in order for this to make sense. And here it is. Here are these four things. And we actually, at one point, actually wrote them down on a napkin in a bar. So, or really, it was in a bar on a cruise ship for a marketer's cruise, online marketers. We had to do live coaching. It had to involve strategies and tactics. We had to provide customized documents, and we had our coaching had to complement marketing, and we had to make it affordable or it wasn't really worth doing. I mean, there's no real benefit if it's not affordable. So our biggest thing that we offer is live coaching with Q&A twice a month. And so one of these presentations is a topic that I present. In fact, I've told you in each of these three parts of our presentation, we've had major coaching sessions the second half of 2024, right? So some of our, in a given month, we have two. One is a full presentation. And beginning last year or the year before, we not only have what my part of the presentation is, we typically, supplement it with handouts, PDFs, that sort of thing. And of course, it's all recorded, so you as a member can see that. There's a lot of information there. And so, that's a quick summary of what we do twice a month and help you stay informed and navigate. So we do have documents. It is a system based on rule-based document assembly, and it works sort of like that. It sort of mimics, as far as you can with software, how you would work with an attorney. For example, the attorney asks questions, you answer questions, and based on that interplay, the attorney creates a document. So rule-based document assembly works the same way. You're asked a question, and then you answer the question. And somewhere along the way, there's a lot of logic in there. Along the way, a question you might be asked somewhere down in the questionnaire is based on an answer you gave previously. So we're not talking about fill in the blanks, that sort of thing. We're talking about intelligent generation of a document, software-based. And there's over 90 documents. It's not just a few. Non-disclosure agreement, model release agreement, some of an intellectual property NDA agreement for employees or contractors who work with you, referral agreement, advertising, copyright assignment, affiliate, all sorts of things. And we have searchable tags on the website so that you can find information we have. We also provide a trust seal, and the feedback we get is that some of our members actually believe and have some indication to back up their belief that the trust seal has helped them acquire customers, to build trust, that sort of thing. So now we've reached the end of my part of the actual presentation, right? And that's an image of me a few years ago. Probably about 5 years ago, speaking on stage, talking about whatever was current at that time. And you can see in the background that 800-pound gorilla, which represents the FTC. And of course, that's what we typically are dealing with FTC Guardian. And I was representing FTC Guardian on a presentation on stage of probably about 300 or 400 people, all of whom were marketers. And so, Alan, we're now through with my official part of the presentation, and we'll be available for Q&A and provide, some Q&A for any questions that we might have.
Can you hear me, Chip?
Yes, very well.
You want to go ahead, and I think it's the next slide that gives them the URL.
Oh yeah, that's it. There we go. I'm one slide short, and Alan will tell you a lot more about this, but in order to, get into the order of the offer to become a pro level member, this is the link right here, ftcguardian.com/special. That's the link. So now while that's on the screen, do we have any questions? And then after I'm through with the questions, Alan's going to take over, explain a little bit more about, how this thing works, and answer other questions, that sort of thing.
Yeah, and I'll walk everybody through the membership area so they can see what that is. Got a lot of questions, but it's funny. A lot of them start with, does FTC Guardian cover this? There's one that I saw that didn't kind of start that way, and it had to do with affiliate marketing. So I want to get that one out of the way first. How can I assure my affiliates are not putting me at risk with non-compliant marketing and practices? I mean, that's just kind of.
That's a good question. So how could you be sure? The short answer, and I don't mean to be flippant about this, but the short answer is you need to be in compliant with what the FC says you should be doing, right? And I don't mean to be flippant, but way back, I'm thinking, I don't know, I lose track, maybe 6, 7, 8 years ago, the FTC decided that they needed to put the burden on the affiliate manager whose products were being sold by these downstream affiliates, because the affiliates were sort of going crazy out there, making all sorts of crazy claims about the product or service, right? And the FTC couldn't chase them down, right? And so the FTC says, we're going to hold the affiliate program manager responsible for monitoring the actions of the affiliates. And we're going to hold that affiliate program manager liable for violations that the affiliates are doing. So there's got to be a lot of follow-up and monitoring, and then management. And if one of the affiliates is stepping out of line, they need to be, stopped, instructed about what to do, maybe have their commission disallowed for the transactions that involve misrepresentations, that sort of thing. And if the bad behavior continues, they need to be terminated in a very short form. So it really now is the burden of the affiliate manager to manage and control those affiliates below. And I will tell you this story very quickly. Years ago, I was at a continuing legal education conference in Austin, Texas. And, attorneys have a CLE, or continuing legal education, requirement of so many hours every year, failing which you're disbarred, right? So you've got to keep current, and you've got to take these courses that are accredited. You can't just sign up for anything. They're very, very serious about forcing attorneys to keep current with all the changes. And so one of the speakers there was from the FTC, not talking about affiliates at all, talking about privacy issues. That was it. And so he goes on for about 45 minutes, and we're in the ballroom of a big hotel, and his presentation is over. So I'm near the back. I slip out in sort of the lobby area. I had a question I wanted to ask him. And so he's out there, and I sort of got to him first, and I said, okay, I got a quick question for you. What is really bugging the hell out of you? What is really bothering the, generally speaking, FTC enforcement? What is top of mind? What are you really concerned about most? And I expected him to say something relating to privacy, because that's what he was doing with the FTC. And he said, no, it's these damn affiliates that are all running around. They're not being managed. They're making all these misrepresentations, deceptive earnings claims. They're driving us crazy. Well, this is right before they came out with the requirement that the affiliate manager is responsible for managing downstream. So that's probably a long answer to the question, but that's the answer I'm giving.
Here's another one. Can I still use customer testimonials if they don't explicitly state typical results?
Well, yes. Well,
Another thing, yeah.
but that's a little bit misleading. Let me complete the answer. The testimonial might say, if it's an earnings claim related testimonial, I made $5,000 my first month into the program. That's the testimonialist. And then you, as the marketer, the advertiser, you use that on your website, let's say. So your use of a so-called success story testimonial with a specific result. The testimonial in this example isn't, I made a lot of money and I'm very happy. It's, I made $5,000 in my first month. Very specific, right? So the testimonialist is not liable. We're assuming it's all true, right? But you're using it, and your use is attributed to you as making the ad claim that the testimonials really gave you. So even though it's not you speaking, you're using the testimonial, and therefore you're responsible for the claimed result, meaning that you need to either be able to substantiate, and we're going back to this framework we talked about with earnings claims at the very beginning, you need to be able to substantiate that other consumers would basically achieve the claimed result or something very close to it, meaning that the result of that testimonial is typical. It's a typical result. Or if it's not, it's your responsibility to then make a little disclosure of what is typical. One of the classic examples of a company doing it correctly is Nutrisystem.com. They have a weight loss program. They sell basically packages of prepackaged low carb food. And basically, if you eat that food and don't cheat and maybe exercise a reasonable amount, you will lose weight, right? And so they rely at Nutrisystem.com, they rely on a lot of testimonials. And so you will see Susie Q saying, I lost 60 pounds. And it does not say in 10 months or any time period, because that means the substantiation burden on you is a lot more difficult, right? So Susie says, I lost 60 pounds. Betty says, I lost 80 pounds. All these testimonials, right? But then at the end of that headline, Susie lost 50 pounds, is an asterisk. And then down below, there's another linking asterisk that says, expect to lose 1 to 2 pounds per month. So that is the generally expected result disclosure. So that's a classic example. And if you really want to see how they did it, now they did a really good job, in my opinion, go to Nutrisystem.com, see how they did the success story testimonials, and also how they linked up the claim that the testimonialist made with the generally expected results disclosure. That's a long-winded answer.
Here's another one. I mean, I hear you say it a lot when we do these presentations and stuff. What are the differences between FTC guidelines and rules?
Yeah, we covered that a little bit in the presentation. The guideline is basically sort of what you think of when you hear the word guideline. It's basically a general result that the FTC expects to avoid a deceptive ad claim, which is in violation of Section 5 of the FTC Act, right? And so within the guideline, and again, I use this classic example of the subscription. The guideline might say it should be easy for a consumer to cancel the subscription, but within the realm of acceptable easiness, there may be 3 or 4 different ways to, I hate to use the skin the cat, but to accomplish a result that falls within easy, right? So you've got wiggle room, you've got flexibility within that guideline to satisfy it, right? But a rule, on the other hand, basically says there's only one solution, and this is it. And if you don't do this, you're in serious trouble. You're in violation. And with with a guide or guideline, the FTC, if they want to bring an enforcement action, the FTC has the burden to prove that your way of deciding how to accomplish compliance for the guide is deceptive. It was not acceptable. It was not easy, right? They've got to prove that. They've got the burden of proving it. On the other hand, if it's a rule and the guide and the rule says the only way to satisfy this is to have one click to cancel. That's it. There's no other way that will suffice. One click to cancel, you either have it or you don't. And if you don't, you're in violation. And the FTC has no burden to prove that it was deceptive. They only have to prove that you didn't have a one click to cancel. Deception is basically assumed by virtue of the fact you just didn't have the one click to cancel. And so then the issue of fines starts kicking in. So it's a huge difference between a guideline and a rule in terms of your potential liability. Massive.
In that answer, you answered another question as well. So but here's somebody who evidently has been really listening to you, because they put something in quotes as, how does the FTC typically identify businesses for enforcement, and how can I avoid being targeted? Stay compliant.
That's a good question. So let's go back to the framework that I mentioned for earnings claims, right? And the top half of that doesn't involve the new material that says you can't use disclaimers to contradict net impression and your duty to track results and all of that. Let's just deal in the top half with the focus on typicality. And I view, when I talk to clients about it, and also when we're doing coaching for FTC Guardian, I say to them, and I'm not being flippant here when I say you need to play the typicality game. And, if you go to business school, which I did for a year, and then I'd had it with law school, and then 1 year of business school, I had it. But in business school, they use game theory for almost anything. And with respect to FTC compliance, in essence, game theory can be applied. There are things going on. There are rules to the game. There are penalties for violating the rules. And there are winners and losers, right? Of a football game, a basketball game, or on the playing field in the marketplace, right? And so basically what I preach above everything else is what you need to do is to focus on demonstrating compliance, because the FTC can so easily surveil you to see what you're doing. You need to basically fly a flag up there that says, "Hey, I'm here, and I'm demonstrating by what I'm doing right here that I understand the requirements, and I'm making a very serious effort to comply." You're demonstrating it, and a lot of it has to do with, when we're dealing with advertising or earnings claims, a lot of it has to do with your messaging, right? And basically what I do a lot in my law practice is I do what I call legal copywriting, right? Because just a few words can make a massive difference. A few words can send a signal that you're not in compliance, or a few words can send a signal that you're demonstrating it. And when the FTC sees that, they say, fine, we'll move on, right? And a classic example was a conversation I was having with a client yesterday. And the client was selling a money-making opportunity, and in a way that the objective was to avoid regulation as a business opportunity known as a biz op, right? So we want to be able to market and advertise this opportunity in a way that doesn't trigger regulation as a biz op, because the requirements are very difficult. And so one of the requirements, or one of the elements of a regulated biz op, is that you're selling a new business, and of course you're getting paid for it, and you're providing outlets like an internet, like a website or an Amazon store, let's say. And that, if you can check those three off, you are a biz op and you're regulated. So you're trying to avoid it. And the statute says that there's a training exception. If all you're doing is offering training, and you're not, doing the outlet or the website or the Amazon store, you're not regulated as a biz op. Okay, so we're talking about that. And he says, okay, here's the headline for my sales page, right? And we're talking about overall net impression, right? What is the message you're delivering to the reasonable consumer? And he had this, he used the word coaching and making money, whatever it was, right? And I said, wait a minute, stop. This is a subtle difference between the word coaching and the word training. And the difference is the exemption from regulation as a biz op is known as the training exemption. And if you read it, it's one long sentence, and it talks about training. It doesn't say coaching, right? So I said, look, it's really important to use the right language to demonstrate that you're compliant. Don't say coaching. Say that, you have a training program, which is true. So, the words make a difference. Context makes a big difference. So it's sort of like, obviously you need to know what the requirements are, and you need to know how to navigate. In this example, you needed to know that the training exemption was what you needed to hang your hat on. So you need to have that knowledge. And then you needed to understand how to play the typicality game and use the right language. So it's really about demonstrating compliance, sending the right message. In this particular very narrow, answer to the question, use the word training so that you're now matching up with that training exception. Don't use coaching because it's not used in the exception. It's training. So you have to have the basic knowledge, but you also have to then use that knowledge to demonstrate that you're in compliance. That's the big thing. Demonstrate compliance, send that message, and be worry-free, basically. That's the idea.
I have two questions. I haven't asked
one. That's a very
one.
long-winded answer.
Yeah, I have two, but I haven't asked you the one about influencers yet, have I? I didn't say anything about influencers yet.
No, you haven't.
Okay. What do influencers need to disclose about their relationship with my business?
Well, there's some details there about the correct language to use. They need to make a disclosure, right? That they have a special relationship with this company they represent online, right? And there are a lot of very detailed words. Is hashtag ad sufficient, or is another different word better and preferred? And I have to look up things from time to time just to see, because sometimes they change. So the answer is yes, there is a special relationship between the influencer who is attempting to influence consumers to buy, the company's products that the influencer represents. So that relationship has to be disclosed conspicuously, right? That's the word. And so usually it's in the form of a hashtag, and the correct term has to be used. And as long as that's being done, you're pretty much okay.
All right. Last one, and it's AI related, and that's
Okay.
if I use AI like chat, Claude, etc., for marketing, what specific risk should I be aware of?
Okay, that's a good question, and it relates to a coaching session that we have coming up shortly. I think next month, I believe, if I'm correctly, it's in February. Um, the FTC, and I'll give I'll give you an answer that's a little bit long-winded, but I think it's important. That is, the first time I even heard about ChatGPT, I think was late 2022. And very early 23, I started dabbling in it. And you sort of helped, you got started a little quicker, and you gave me some, some pointers on how to use it and how to download it and all of that. And we're now into early 2023. And now, based on your help, I got involved in ChatGPT, played around with it, and was really just blown away. I just couldn't believe it. And I was thinking at the time, and the reason I mentioned this is I was thinking at the time, it's going to take the FTC, I don't know, a year or two before they come out with anything related to, how they might regulate this darn thing. And I was really wrong, because I think within about 3 or 4 months of my thinking that, probably in February of 23, it was before July of 23, mid-year, that they came out with a listing of 2 sets of concerns that they had for marketers with AI. One had to do with the use of AI to enable a product or service. In other words, you're selling a service or product that embeds AI, and therefore there's typically a competitive advantage because AI is doing something that's really not possible without AI, right? So it's involved. It's an AI-enabled product or service. And the concerns were, does it really work as advertised, et cetera, et cetera. And then on the other set of concerns, these were concerns that they had. In other words, these are things we're worried about already, and we're going to be focusing on future enforcement actions with AI-enabled products that misrepresent things, including, does it really work as advertised, and then others. Then the other list was something called language that they used, the luring test, lure, like fishing lure, the luring test, because they were worried that marketers would somehow use AI to unfairly influence consumers to take up a call to action, usually buying something, right? But whatever the call to action is. So they had these lists of concerns. And then I'm thinking, okay, well, that really surprised me. And it was just about 5 or 6 months later, they came out with their first case. So they were on this thing way quicker than I thought. And let's fast forward from 2023 to late 2024. I believe in the November timeframe, maybe December. I can't get the date exactly right. The FTC comes out. There've been a few cases in the interim, and then in this most recent situation, they have come up with something called Operation AI Comply, and you can Google that, Operation AI Comply, and it was a list of 5 or 6 enforcement actions that the FTC had recently taken involving companies using AI in some marketing capacity. And again, those cases related back to the concerns they listed earlier in 2023. And what was your question? I'm getting right up to the answer, but what was it?
It
Do you
was
remember?
specifically, if I use AI like ChatGPT for marketing, what specific risk should I
Okay,
be?
well, so my answer is, now with all that background, Google AI, FTC AI Comply. You'll see a summary on an FTC press release that gives you a little paragraph about each one. But some of them said our service is powered by AI, that sort of thing, and the FTC came down on them because they couldn't substantiate what their claims were. But there's one that really is interesting, and we're going to have we're going to talk about the whole AI comply as a group very early, I believe in February, but there's one that we're going to cover in detail, and the company involved in the enforcement action is called RYTR. I don't know how to pronounce it, RYTR. And RYTR had an engine driven by AI that would generate testimonials. And you could then go in and click on certain types of, make it funny, make it this, make it that, whatever, and put in some basic facts. And it would spin up a whole bunch of testimonials. And the FTC said, wait a minute, that the wide range of testimonials that were generated by AI, some of them went far beyond the parameters that got input, right? And they were deceptive, they were untrue. So the AI was not limited to the facts that were put in to essentially train the answer. They went above and beyond. So the FTC said, we're going to file an enforcement action because the users of this service are likely, and it's likely that they may violate, they may create deceptive testimonials. So obviously the two Republican members on the commission basically dissented because the Republican members want to go after only violations that have actually occurred, right? Not a situation where somebody is setting up a situation where they may occur. So there were two members on the Republican side in the minority who said we don't like this. We're going to dissent. The Democrats went ahead with it, and of course we've got the Trump era of the new FTC in the works right now with all these confirmation hearings, and it looks like the new chairperson for the FTC I can't remember his first name. It might be Edward, but it's Ferguson. He's one of the Republicans who dissented. So he is looking for a more limited scope of what they're going to be enforcing in the future, beginning in 25 and beyond. So that's sort of how the Republicans look at it. And we'll see how it all works out. That's a very long-winded answer to your question.
That is it, Chip. I'm going to try, if you'll stay right there for a second, I'm going to try to take over the screen.
Okay.
And let me do a show my screen.
I can see it.
Which one do you see?
I see a part of a home page.
Do you see, like do you see yourself there?
Wait a minute. I don't see. Wait a minute. I'm seeing myself, but it's not the home page of the website.
Yeah. People can see, pause. Okay, showing screen. Yeah. Okay. I've got it. So I've got the screen, and all's good. And I'll take it from here, Chip. All right?
Okay.
All right. Thank you, sir.
Thank you. Bye.
Bye. Okay, everybody. Let me just confirm here that everybody can see the screen that I think we can see. That's the one. It says clean. There we go. Okay. Yeah, I just want to confirm we can see it. So when you go to the link, the ftcguardian.com/special, this is the page you're going to land on. And what you'll notice is that there's a $4.97 offer. And I mean, for that, you can't beat it. It's a one-time payment. You can't beat that. If you, for some reason, think you might want to spread the payments out over 2 payments, you've got that option here. You just kind of click over here and you can split the payments up into 2 payments of $297. I'm sure you can see that what we do, the documents we provide, and I'll go through some of that, the documents that we provide and the training that we do twice a month is, priceless when you get right down to it. You've got Chip as a full-time FTC compliance attorney who's on top of this, day in and day out. I mean, heck, just yesterday, he pinged me during the day. We had a training class yesterday, I think it was, and he pinged me during the day. Hey, we've got to make some changes to the program because something just came out Monday, and we've got to talk about it because we need all of our members to absolutely know this just came out on the 13th or yesterday, whatever day it was that just came out. So it's invaluable. And again, the other thing nice about it is the membership area. Everything we do goes into the membership area. So you would have access to, after you become a pro member, you have access to FTC Guardian's membership area, which is basically what you need. And you have access to all of our documents. So, for example, we've got the basic documents here. If you're just kind of starting out and you want to create some documents, you have access to all the documents in here. This is Michael saying I just logged into his account. It was easy. There you can generate documents. You can download the documents that are here. As a pro member, you basically want to create all the documents that we have in this category, except for the privacy policy. And for the privacy policy, as a pro member, you want to come in here and create the privacy policy from the supplemental category, because this has some upgrades to it, to the information, and that's the one that you want to create. Again, and then we have, customer agreements, and you can download these things and see everything we have. Channel marketing, like affiliates and stuff like that. There, you've got those type of agreements in here, marketing agreements. If you're a digital agency, we've got digital. Oops, I guess that's an upgrade. Mike is not a digital agency, but for digital agencies, we have documents specifically for digital agencies. Let me see, enterprise member requirements. Okay, we have some stuff there for that. Let's see. Oh, let me go down here a little bit too. You scroll down, we've got rules of the road, a lot of updates, cheat sheets, marketing agreements. These are all just a lot of PDFs and marketing stuff. Another really cool feature before I run off to the membership area. Let's go back. If I go here to search, if you're searching for something specific, let me just type in AI. This is going to pull up everything that has AI in it. Let me see if I can type in chat. I don't know if chat would be a search term. Yeah, there's chat, GTP. So if you want to look for, we call them tags. If you want to look for something specifically, you can come in here under the search and pull up, different stuff under here, ad claims. We want to see everything that we've done in the past about ad claims. Here, there you go. You can have access to everything that we've done in the past and into the future, right? So the membership coaching area is here, and you can see a list of all of them. There's always a video, not always, this one in December, the first time ever out of all, since 2014 or whatever, the first time ever the GoToWebinar didn't record the video for whatever reason, but I provided all the documentation and everything there. But videos with downloads attached to everything, what we discussed, and PDFs and or Word documents for you to download for yourself. So, there's not any better time than right now to get started. We make it super, super simple. We'd love to see you on the next coaching class that we do. Again, we do them usually on, well, we say usually, we always do them on Tuesday. We've been doing on Tuesday since 2014. So usually twice a month on Tuesday, we usually do one, the first one of the year, the first one of the month, like it's 7 o'clock Eastern. And then the second one that we do of the month is usually at 8 o'clock. It is, say usually again, It's at 8 o'clock Eastern time. So that's them. And again, you can log into them, and or if you, for whatever reason, you can't log into them, or if you have questions, you can email support at FTC Guardian, and Chip will answer the questions. And then you can always log into the membership area and have your questions answered there. And because Chip will, I'll go over, I'll feed the questions to Chip, and he'll answer all the questions, and they'll be in the membership area as part of the video. So everything is there. Now's the time to get started. We'd love to see you here. Also, there's a little help button down here. It's got a little library of stuff, so you've got that. So everything is here. If you're working online, you know, I really don't care what type of business you are. If you're an HVAC contractor, an online marketer, e-commerce, landscaper with a website, if you've got a website and you promote yourself via, you know, any of the socials, Facebook, Instagram, TikToks, or any of those things, and you know, it's kind of how you grow your business anyway, is sending people to your website. You know, it's funny enough, I was at my insurance agent's office yesterday. I think it was the day before yesterday. I'd never met him. Been doing business with him for quite some time and had never met him. And my wife and I were on that side of town or whatever, and we went in and we got started talking to him, and the owner of the insurance agency said, yeah, very few people ever come to office anymore. It's kind of like nobody does that anymore. And because he had a really small office, and it was like, yeah, it's wild. It's nobody goes to offices anymore. Everybody does everything online. So if you're online, you know, using a website, text messages, you know, whatever it is, email to get customers and or promote your business or tell people about what you're doing, even if you're a restaurant, you need to be compliant with the Federal Trade Commission. And there's no better way than using a service like FTC Guardian. I say like, we're the only people out here that I've known since 2014 that does exactly what we do. There's nobody else that does it. Chip's been doing this since the beginning of time. Started out in software law and moved into FTC compliance when the internet really took off back in 95, 96 timeframe, and compliance became such a big issue. So he's the guy you want to work with, and we'd love to have you as a member. So now's the time to sign up for FTC Guardian, and we look forward to having you in the membership area. So if there's anything else we can do for you, just email support at ftcguardian.com, and we look forward to having all of you on our next coaching session. Appreciate it. Thank you, everybody. Goodbye.